of President Trump's environmental actions have faced court challenges. So, how's the administration doing? This is Trump on Earth. I'm Julie Grant. We've heard about many rollbacks in environmental regulations by the Trump administration, at least 100 at last count. But how are those efforts holding up in court? And how might a shift in the Supreme Court impact environment and climate cases? We have a couple of guests to talk about it, both experts in environment and climate law. First, Ann Carlson, professor of environmental law at UCLA, is here to talk about a climate change case just added to the Supreme Court docket.
Several municipalities around the country, along with several states and counties, have sued big oil companies for damages caused by climate change.
These local and state governments want to hold energy companies like Chevron and Exxon responsible for damage from sea level rise, hurricanes, and wildfires they say have increased because of climate change. So cases have been filed in state courts around the country.
Courts in Minnesota and in Baltimore and all over California and in Boulder, Colorado and New York City, city of Seattle, Charleston, South Carolina, Hoboken, New Jersey. And the oil companies would prefer that the cases be heard in federal court instead of state court. They have been fighting this battle for several years, and they've lost in almost all of the courts that have considered the question. But the Supreme Court just took up one of the cases on a really technical ground, and that is, when can oil companies appeal motions that they lose about whether they can be in federal court? Typically, they can appeal only after trial, but the question the court is going to consider is whether they can appeal immediately upon losing the motion.
If even one local government wins one of these cases, Carlson predicts a cascade of similar lawsuits against oil companies, which could cost them many billions of dollars. So oil companies want to appeal state court rulings and move these kinds of cases to the federal court system, which is considered generally more sympathetic toward business. And Carlson thinks energy companies really want to delay trials in state courts that might expose their executives to public scrutiny about how they reacted to information about climate change.
The real consequence, if the Supreme Court finds in favor of the argument that the oil companies are making, it will slow the cases down. It will give the oil companies more opportunities to appeal decisions that they don't like. And really importantly, it could keep oil companies from having to answer what's called discovery, where the plaintiffs would have an opportunity to interview under oath executives of oil companies about what they knew about climate change, when they knew it, and what they did about climate change. And I think oil companies are really trying to avoid that. I think they don't want a repeat of some of the things that happened to the tobacco industry. And so delay is to their benefit. If the plaintiffs win, then pretty quickly after the decision, I think we will begin to see that discovery, that process where plaintiffs and defendants can get information from the other side. And you may see some potentially explosive testimony and documents, again, about what oil companies knew, when they knew it, and what they did about it.
Carlson is not sure that a new 6-3 conservative leaning on the Supreme Court will affect the specific decision that justices will be deciding in this case. And she doesn't see much in the history of Judge Amy Coney Barrett, Trump's nominee to replace Ruth Bader Ginsburg, in how she might decide an administrative law case like this. Ann Carlson is an environmental law professor at UCLA. And we should note, she's been doing pro bono legal work to support some of the local governments against energy companies in these types of cases. We'll be back with a look at Trump's environmental legacy and the courts. I'm Julie Grant with Trump on Earth. To take a look at how the Trump administration has been faring in court, we turn to Michael Gerrard, professor of environmental and climate law at Columbia University. Hi, thanks for joining us.
It's my pleasure to join you.
The administration has rolled back about 100 environmental regulations, and many of these have been challenged in court, many of these rollbacks. How's the administration been doing so far defending those changes?
The administration has accumulated a very poor win-lose record in court. in its deregulatory actions. That is primarily because they've been sloppy in following the necessary procedures. There are statutes like the Administrative Procedure Act and the National Environmental Policy Act that need to be followed in adopting or revoking or significantly modifying a rule, and they've often just bypassed that or tried to eliminate something without coming up with the thorough explanation that the courts require. And so many of these actions have been halted by the courts.
And oftentimes the court seems to give the agencies the ability to go back, and if they don't agree with how the agency has moved forward, and say, hey, you can review your work. If there was to be a Biden administration, what can they do in these cases? And could they completely change a rule from what the Trump administration had done?
If Vice President Biden wins the presidency, I expect that very early on he would revoke many of the Trump executive orders, which rescinded some of the things that were done. But to the extent that the Trump administration got all the way through the formal rulemaking process, a Biden administration would have to go back through that process again to revoke the rule that had been adopted. None of the actions that were taken were irrevocable. There weren't any amendments to the statutes that would require congressional action, but some of the things could be undone immediately. Some of them would take a while.
Yeah, and in terms of the Trump administration, if they were to move back into a second term, could they take some of these cases, review and revise these? Do they have to do a whole new rulemaking, or can they just change them and then wait and see if somebody challenges them again in court?
If President Trump is reelected, I expect that they will try to go back and do this again for many of the rulemakings that were struck down because they didn't follow the right procedures. They may well have learned the lesson and do it right this time, go back through a full rulemaking. So it would take some time. It would take at least several months. But if he's reelected, they'll have 4 years to do that, and I expect that they would carry through on many of the things that they tried to do the last time but were halted on procedural grounds.
And you've mentioned that there's been a significant percentage loss, but there have been some wins by the Trump administration in their attempts to roll back environmental regulations. What are some of the big wins we've seen under this administration?
There are some methane rules that have survived, but most of the rules either were struck down or the litigation is still pending. There are very few that have really gotten all the way to the finish line and have been wholly upheld. Most of the cases are still pending.
Well, is there like NEPA? Is there something in particular you might point out that you say, they really got what they wanted here?
No, not yet. I mean, for instance, with NEPA, with the regulations under the National Environmental Policy Act, they have gone into final form, but there is litigation that is pending right now, several lawsuits that are pending right now, and they have a certain vulnerability. We'll see what happens with them. Likewise, the rejection of the California waiver for motor vehicle standards, which allowed California to have stronger standards than the national level for emissions from cars. Some of that has gone through, but is subject to litigation.
So when you see administration officials saying, hey, we think we're actually doing pretty well, it sounds like you disagree with that.
I do disagree with that. They have certainly succeeded in preventing any new regulations from going through, or in having implementation of the regulations. We've seen a decline in enforcement. We've seen lots of other things happen that are going contrary to environmental protection. They have certainly succeeded in that, but they have not succeeded in actually revoking a lot of regulations and having those survive through the courts.
The Supreme Court is, of course, front and center right now with the passing of Ruth Bader Ginsburg and Judge Amy Coney Barrett being nominated. I wonder are there any cases, how likely are the Supreme Court likely to hear some environmental cases? Are there any you'd want to point out?
I think it's highly likely that the Supreme Court will hear more environmental cases. One that we're particularly looking at is on October 8, the U.S. Court of Appeals for the District of Columbia is hearing oral argument in the lawsuit that is challenging the Trump administration's repeal of the Clean Power Plan and its enactment of a very weak substitute called the Affordable Clean Energy Rule. So after the D.C. Circuit rules on that decision, whoever is unhappy with the decision might try to take that to the Supreme Court. And that could provide an opportunity for the court to revisit some important issues on climate change. There will undoubtedly be other cases on environmental regulations that could also be brought to the Supreme Court.
Now, if Judge Barrett is confirmed and winds up on the court, now obviously that's not going to happen in the next month, but it could happen before a case like the one you just mentioned makes it before the Supreme Court, if it does. I guess I wonder what a 6-3 conservative court would be, what you might expect them to do with a case like that.
Well, it's very worrisome. The Supreme Court decision that really formed the basis for most of the actions by President Obama on climate change was Massachusetts versus EPA, issued in 2007, that found that the state of Massachusetts had standing to bring the lawsuit and that the Clean Air Act applies to greenhouse gases. So it was a 5-4 decision. The majority included Justice Ginsburg. It also included Justice Kennedy, who has been succeeded by Justice Kavanaugh. Now, Justice Kavanaugh is the member of the court who seems most skeptical of EPA regulations. And so there are two worries here. One is that the Supreme Court might find that the Clean Air Act does not apply to climate change. Now, that's something that Congress could fix. If the Democrats have the Senate and the House and the White House, Congress could pass legislation making it explicit that the Clean Air Act does apply to greenhouse gases, and so that would undo that. It's also imaginable, I'm not going to predict it, but it's imaginable that the Supreme Court would restrict standing, would restrict the ability of parties to sue on climate change, on the theory that in order to sue, you have to be affected differently than the public at large, and everybody's affected by climate change, and also on the theory that in order to bring a lawsuit, you have to have redressability, that you have to, if you win the lawsuit, it has to get you what you want, and if what you want is no climate problem, then no one lawsuit will do that. So there is some risk that the Supreme Court could turn around on the standing doctrine, and that would be tougher for Congress to overcome because it's based on the Constitution, not on the reading of an ambiguous statute.
Are there any other ways you think her appointment or if she becomes the next justice on the Supreme Court might impact the future of climate policy?
There's a growing philosophy among some conservative legal scholars of something called the non-delegation doctrine, the idea that Congress shouldn't delegate too many policy decisions to administrative agencies and instead have to be very specific, because otherwise the agencies can go wild. Many of the environmental statutes were intentionally general and left it to EPA or other agencies to figure out how to achieve their objectives. It is possible, we don't know for sure, but it's possible that a reconstituted Supreme Court could embrace that doctrine and use it to invalidate any number of regulations that are not really specific. Now, there is one similar kind of precedent where Congress felt it needed to be a lot more specific in the way it wrote the laws than usual. In 1984, under the Reagan administration, we had a Democratic Congress that did not trust EPA to vigorously implement the environmental laws. Chief issue then was hazardous waste. And so Congress passed a law in 1984 that was much more specific than it usually does. It named a lot of chemicals. It was very, very specific, so that EPA would not have the discretion, would not have the wiggle room not to implement it. And so that that worked. That 1984 statute was successful, and EPA had to follow it. So one could imagine that happening again. That if we again have a Democratic Congress and President, Congress adopting on climate change and maybe other environmental laws that are much more specific than it's used to doing.
It's very interesting because you think your experts are probably going to be at your agencies and not in Congress. I'm just thinking about when President Trump nominated Neil Gorsuch to the Supreme Court, we were hearing a lot about this idea of Chevron deference, how the courts would defer to the agency in areas of expertise on scientific, on policy matters, or would it maybe be better if you explain that? And it sounds like what you're saying is a different interpretation of sort of who's in charge.
Yeah, there's a longstanding legal doctrine called the Chevron doctrine, which basically means that if a statute passed by Congress is ambiguous, then they'll defer to the agency's reasonable interpretation of what the statute means. So the Chevron doctrine has been under attack by a number of conservative legal scholars and some members of the Supreme Court. So it's possible that if we can have a 6-3 conservative majority in the court, that we'll see less of this Chevron deference, as it's called, and it would be harder for agencies to adopt regulations. One thing that would be very unfortunate if Congress needs to be extremely specific in setting forth its the procedures that EPA or other agencies have to follow is new environmental issues are discovered all the time. Congress can't always anticipate it. When Congress passed the Clean Air Act in 1970, very few people were thinking about climate change. But the language in the statute is broad enough that it encourages EPA to look at new scientific discoveries and deal with them. But if the Congress needs to be really specific, that's a big problem for environmental regulation with these new discoveries we have all the time.
I'm not sure how worthwhile it is to talk about, to go deeper into this, but just to kind of try to complete that thought in terms of, for someone who's concerned about the agency's rulemaking under the current administration, and if the Trump administration should get a second term, does it make sense what you're talking, like a court that is inclined toward Chevron deference as compared with, say, Congress really spelling out what it wants in a regulation or how it wants agencies to move? I'm just trying to mix these ideas and see, what do we wind up with there? What's happening there? From
an environmental perspective, the worst outcome would be that the courts give little deference to EPA and its authority to regulate, and we don't get any new statutes passed. Congress has not passed a major new environmental law in 30 years. We have a lot of new science in the last 30 years, and so EPA has been struggling with coping with these new problems with laws that are a generation old. Some of them are 2 generations old. Some of them go back to 1970. We really need Congress to act, but Congress has been completely paralyzed by these partisan divides. There aren't enough votes to get anything done. And so if the courts are very restrictive in the ability of the agencies to deal with new problems, that's a major overall issue for government. And so something like, I'm just trying to make sure I understand what you're saying. So with a conservative court, if you have a 6-3 court, you would assume that what that means for the agency, for the EPA and other environmental rules that are coming out of the administration, not out of the legislature. Well, for instance, the Clean Power Plan was the set of regulations adopted under the Obama administration to try to cut back on the use of coal to generate electricity. There was a lot of pushback that the Clean Air Act wasn't specific enough to allow that kind of regulation, and that's an issue that'll be argued before the D.C. Circuit on October 8th. But if the courts say that this kind of thing goes too far, that the wording of the statute needs to be much more specific than it is in order to regulate pollution from these existing coal-fired power plants, then it's removing a very important tool from the toolbox that the government has to try to control this major source of pollution. That's not to say there's nothing else that could be done, but it makes it a lot harder. You're tying one hand behind the back of the agency.
It's interesting, and this may be neither here nor there, but when President Trump is asked about climate policy, he talks about pristine air and clean water. And that's in response to questions about climate. So he's sort of conflating these things.
Well, pristine air would also mean you're not putting greenhouse gases into the atmosphere. And most of the sources of greenhouse gases are also sources of conventional air pollutants that make people sick directly, like carbon monoxide and sulfur dioxide and particulate matter and so forth. So if you really had clean air, you also wouldn't have nearly as much of a climate problem. But the Trump administration has not been advancing clean air either. They've been cutting back on enforcement. They've been cutting back on EPA regulations under the Clean Air Act, and also under the Clean Water Act. And so they've been moving in the opposite direction from clean air and clean water.
Is it accurate to say they're also trying to say they do not have the authority to regulate climate pollution, like to regulate greenhouse gas pollution?
They haven't gone that far. Various people have urged them to try to revoke something called the endangerment finding, which was the formal finding that greenhouse gases do pose a danger to health and welfare. But they have not tried that. And EPA and the Justice Department actually have not denied climate change in any of their rulemakings or court filings. That's wise on their part because they'd get nowhere in the courts. They'd have a lot of difficulty. Instead, they're just trying to greatly weaken the regulations that are aimed at climate change.
From what we've seen, the administration sort of, because it's not considering climate change in some of its rulemaking, working against it in some court cases. Can we talk about that a little? How some justices are saying, hey, you haven't considered the impact of climate change here, and that's something that needs to be part of this policy making.
So one of the issues is under the National Environmental Policy Act, agencies have to consider the environmental impacts of actions they're taking. And a number of courts have said that if you're approving a fossil fuel project, for instance, you need to at least consider the impact that it will have on climate change. And a number of actions by the government have been struck down because they haven't done that, like the leasing of federal lands for coal mining or the approval of natural gas pipelines. But the Trump administration has resisted any even mention of climate change or greenhouse gases in some of these analyses, and it's gotten into trouble for that because some courts have said you really need to look at it. It doesn't necessarily mean you have to deny the project, but at least you have to disclose and consider it.
So what happens if a court says that they now go back and, do they have to consider that in order to move forward, or?
Yes, they have to go back and do a new analysis that does consider and talk about climate change and greenhouse gases. And if they do that, they can often move the project forward because this statute, NEPA, is about disclosure and consideration. It doesn't compel a result.
So even if the administration does not like to talk about climate change per se, the courts is kind of being forced to in some court cases.
That's right. I think some of the officials in some of these agencies are afraid to even utter the words climate change. But the courts are saying you have to. In
some of the articles that have been written, there's a sense that the administration has been in such a rush to push its agenda that it hasn't always dotted its I's and crossed its T's. We'll put it that way.
Well, that's been a very common phenomenon. That's why they have the chief reason they have such a poor won-loss record, that they haven't dotted their I's and crossed their T's, and they get called on it. And the courts do not like to see these procedural violations. The courts tend to be more forgiving of substantive issues, but they don't like to see these serious procedural breaches, which the administration has done over and over and over again.
And just for people who may say, well, why do they need to follow these specific procedures? Why is that so important to the courts?
Each of these procedures serves a very important function. They serve the function of telling the public and the regulated community and everyone else what they're thinking and give them the opportunity for input and comment. If you don't give that opportunity, your regulations are not going to be as valid as technically sound, because there are a lot of people who know things about what's being regulated beyond the government officials. Congress has also deemed in NEPA and other laws that it's important to think about the environment when you're making big decisions that could have an environmental impact. We have a procedure for how you systematically disclose that. So if those procedures are ignored and you don't systematically think about environmental issues, you're likely to have a worse impact. And so the courts are insistent that those kinds of procedures be followed.
If we do have this 6-3 conservative majority at the Supreme Court, what other options is Congress, is the government going to have to deal with climate change?
Well, the most important thing that could be done to reduce climate change is to transition the economy away from fossil fuels. That involves a massive program of building wind and solar and transmission. It also involves electrifying many current uses and lots of other things to decarbonize the economy. There's a lot of that can be done without laws specifically on climate change. So Congress and the administration could encourage this huge public works program for renewables, which would also be a massive job creation program without any laws that are specifically about climate change.
And are we seeing any of that move forward already? I mean, are we already seeing those kinds of moves, or like you say, is it just too deadlocked? I feel like I should know, but I guess I'm not that familiar with this aspect.
Oh yeah, over the last few years, the cost of wind and solar and also storage have dropped precipitously. They have become much more economical, and they are now cheaper than coal, and even in many cases cheaper than natural gas. So we are seeing the market move in that direction. Solar and wind jobs are two of the fastest growing elements of the whole occupational picture. The technology is developing very rapidly. There's a lot of private money going into it. So we are really making substantial progress in these areas. We need to do more, but we are moving in the right direction.
So knowing this, when you look at, in terms of climate and environmental policy, and you look at a move toward a more conservative Supreme Court, are you've mentioned a few cases and reasons why that is concerning, but in the whole, do you think the market and policymakers can still do what needs to be done here, even if the court is not necessarily on board with some of these more specific actions?
Not at the necessary pace. We're already behind the 8 ball. We need to be reducing greenhouse gas emissions at a much faster pace than we are now. More renewables will make a big difference, but we need to be pulling out all the stops. And it really impedes the efforts if we have a hostile court system.
Well, Michael Gerrard, thank you so much for taking time to talk with us today.
Thank you.
Michael Gerrard is professor of environmental and climate law at Columbia University. Thanks for listening to Trump on Earth. If you like our show, please consider supporting us through Patreon. Just go to patreon.com/TrumpOnEarth. You can find us online at trumponearth.org and anywhere you get your podcasts. Write us a review and tell your friends. The podcast is supported by the Robert F. Schuman Foundation. Our producer and digital editor is Andy Cubis. Kathy Nauer is the executive producer. I'm Julie Grant.